Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. Professional Ethics class. Friends, we are discussing today rule number 36. That is to say that the advocates should not solicit work. The advocate should not engage touts. And the advocate should not solicit by giving interviews, by personal communications like writing letters, and even by not exhibiting so much of flexi boards, and also the number plate also should be a reasonable one. The signboard should be of a reasonable size. This is what rule 36 says. I repeat, advocate should not solicit work or advertise by ads, circulars, touts, personal communications, interviews, etc. The signboard should be of reasonable size. So these are self-explanatory. That's why. Because legal profession is a noble profession, you should maintain its decorum. You must be dignified. You must maintain the decorum also. You should take up the cases whichever come to you, but you should not go after and chase the cases. This is what is happening nowadays. But anyway, there are classic examples where you are supposed not to do. Very famous cases. The BCA inquiry number Tamil Nadu ECR number 10/18. The case is M. Nelson versus Y. Muthumalar. Muthumalar decided on 9/11/2018. Very classic case where the advertisement, all these things will come. So actually, Muthumalar and her husband, both of them, Mr. Jaising, both of them were previously vegetable merchants, vegetable vendors. No doubt they wanted to study. Muthumalar, she took up LLB from Sri Vijayanagara College, Anantapur. She studied in Sri Vijayanagara College of Law, Anantapur in 2011 to 2014 batch, same batch, and passed LLM also through distance mode. Her husband, Mr. Jaising, he joined LLB, but he could not continue the same. This is one point. And after completing the degree, yes, the couple, they have actually in 2014, actually they have taken a shop for rent, and they have signboard, erected the signboard indicating that both are advocates and with LLM degree. So BA LLB, BBA LLB, like that they have written qualification. Then they have got national e-commerce platform and common service centers, that is for Aadhaar, e-Seva and others. Then aluminum fabricators, they are doing interior decoration and also PVC doors, etc. Their email and phone number was also given. That means they are indulging in business also. Not only the legal profession but also business. Already next we are in the coming days we will tell you advocate should not engage in any profession. Already D. Sai Baba case we have discussed. Right? So the main allegation is that during the interregnum period, that means while studying LLB in Sri Vijayanagara College, Anantapur, she worked as a yoga teacher in 2 schools, of course, on honorarium. So, when the inquiry is conducted, it is clearly revealed that she took honorarium from a municipal school. The other school was a private school, so they did not give any documentary proof, but here the documentary proof has come. Right? So, another thing is, this woman, Muthumalar, she has got dispute her brother-in-law by name Mr. Nelson. Nelson approached the civil court and got an injunction order. After getting an injunction order, of course, normally she will be worried, and this man has placed, actually, this man has placed some material, some fencing like that to his fields, and the woman and her husband went there and burnt the same. It has become a criminal case, and Mr. Nelson sent petitions to the Bar Council of Tamil Nadu and Puducherry, and then inquiry started, and they came to know that No doubt she studied LLB, but at the same time she worked as a yoga teacher. Finish. Number 2, husband did not at all continue his LLB. And third one, they have solicited work by establishing so many boards, by installing huge Flexy as an advocate. They have violated Rule 36. So Section 45, that is practicing an advocate without required qualification. Very recently I told you Rajamandri case also. So therefore, and they have violated the injunction order given in OS number 1492 by 2017. So all these things and other business. Rule 49 says the advocate should not do any other business. All these virtually bad qualities have been found, and therefore both of them were removed from the legal profession. Very classic case, please remember. Another important case is in the matter of A, an advocate, AIR 1962, SC 1337. In this case, the advocate, of course, luckily he went to the Supreme Court with the blessings of a political leader. After becoming an advocate, he wrote a letter to the government of Maharashtra soliciting their briefs. My friend, I have become an advocate. Whatever the cases are there on your behalf or on the government behalf of the government, please send the cases to me. Okay. So this is definitely, there is nothing but soliciting of work. And an inquiry was instituted. In the inquiry, before the Supreme Court reached, he flatly denied. And when the evidence or when the signatures or when the handwriting was taken up, then he has to admit. Then he said, what is the impropriety? What is wrong in writing a letter? So he flatly refused and denied in the first. But he also argued that there is nothing unprofessional in writing a letter. Supreme Court held that it is misconduct and suspended him for 5 years. And another case is there, which is also a very classic case. Bar Council of Maharashtra versus MB Dabholkar, 1976. So this Dabholkar and the others advocates, they used to stand at the main entrance of the court gate. They used to solicit passengers. Ultimately, it has become so nuisance that some of them used to take the clients to the library, some of them to the bar room, and actually there was a fist fight between these lawyers. So the matter went to the Supreme Court. In this connection, Honorable Justice late V.R. Krishna, he stated legal profession is a noble profession. It is a 24/7 profession. It is not a butcher's shop. It is not a the so-called hair cutting saloon. You cannot solicit passengers. So like that, so many cases are there. Anyway, these are the standard cases relating to rule number 36, which prohibits advertising. Please remember, the name board or the sign board also should be of a reasonable size. You should not get flexi kodanu. So this is what I want to tell you. So with this, I am concluding. Thank you very much.